Hi everybody, this is attorney Tania Silva. I am the director of the Immigration Force, and today I would like to talk really quickly to employers in the United States and answer some of those, I would say, the most frequent questions that I get asked from employers who are either already hiring immigrants and they are not sure about their status, or those who are interested in hiring foreign help. So the very first thing that you should know as an employer, as an American employer, is that authorization to work in the United States can be proven with 3 different documents by an immigrant. Number 1 would be the green card. And you will see in the green card whether it's a conditional green card or a permanent legal residency or a permanent green card. And it all depends on whether that person obtained their legal status through marriage. So they go through a conditional period of a couple of years before that transforms into a legal permanent residency. So that is the first document that would prove to you that this person is authorized to work in the United States. The legal residency card, or most commonly known as the green card. Secondly, would be the employment authorization document, an EAD, which is commonly known as a work permit. And I am putting here images of those so you know what they look like. Generally, these are temporary permits that are granted to immigrants who are either in some sort of proceeding, whether it is asylum, some sort of deportation proceedings, or some sort of petition, maybe adjustment of status petition. But it means it's given only on a temporary basis. It could also be given to somebody who has, for instance, a U visa. But again, it's a temporary permit, and it is always going to be anchored to another application or to another visa. And finally, it could be just an employment visa for an employer that you already petitioned for. And generally, the employment visa will be stamped on the employee's passport, so you'll be able to see there how long this visa was granted for. And this usually applies, like I said, when you have petitioned for the employee, or in other situations such as an E-2, when they themselves have a business that they're working on here in the United States. But those are the only 3 documents that would prove to you that a person is authorized to work in the United States. A legal residence card, a work permit, or a employment visa. Those are the only 3 that can legally prove to you that somebody's authorized to work. Many of my clients asked me, well, what about the social? If they bring a social, I assume that they are authorized to work. Well, not necessarily. As a general rule, yes, if you have a work permit or if you have a green card, you will be able to obtain a social security card, but it doesn't necessarily mean that you're authorized to work. Because, for example, if you only have a work permit, but for whatever reason, let's say you lost your employee lost his asylum case or his case in immigration court, even if he or she still has a social security number, they are no longer authorized to work in the United States. So those 3 documents are the ones that guarantee you that they are authorized to work here, not the social security card. Now, what are your responsibilities as an employer? You are supposed to check whether the person that you are hiring is indeed authorized to work in the United States. Now, many employers try to circumvent this requirement by hiring independent contractors. And yes, you are not required to check whether the people that your independent contractor hires is authorized to work in the United States. However, you can be found liable for that if they do hire unauthorized employees. If you have a reason to know that those are their practices. So you want to make sure that you understand too what are the hiring practices of your independent contractor, because you can be found liable for their misdeeds, if you will. So please do make sure that you understand the hiring practices of your independent contractors, because just because you are not required to check, if you have reason to know that they are hiring undocumented immigrants, you can be held liable for any exploitation, or actually for the fact that they are hiring undocumented immigrants. Now, more often than not, what I encounter here in my law firm is employers who have this amazing employee with an outstanding work ethic who either loses his work permit, or they just met this person and they really would love to hire this person. And that is the number one question, the million-dollar question that I get asked by employers. Am I able, or how can I hire this person? How can I hire this person? I think she would be outstanding for this company. Well, let me tell you, there are certain requirements. And unfortunately, the number one requirement when we're talking about employment visas or even employment or even residency through an employment, it's that that person must be in the United States with some sort of status. So if you meet a potential candidate while she is on her tourist visa, let's say she's visiting the United States and she's visiting potential employers, and you really like her and you really would like to hire this person, if she's here documented, if she's here with a visa, tourist visa, or say she's graduating from college and she's here under a student visa, then yes, the great news is that you as an employer will likely be able to petition for her. However, let's say her tourist visa expired and she is now out of status and she began accumulating unlawful stay. If that's the case, unfortunately, you will not be able to petition for this person until she leaves the country and passes the time, whatever time she needs to spend outside, given the time that she's been here illegally. Then there will be certain time. It could be 3, it could be 5, it could be 10 years that she will have to stay outside. But you will not be able to petition for her during that time, unfortunately, unless she qualified for a waiver. So speak with an immigration attorney to see what alternatives you would have to petition for that employee. But let's say that you are actually able to petition for that candidate, whether because she is here in the United States with some form of status, with some sort of visa, or because she is back in her country and has not been here illegally, so she's able to, or you are able to petition for her through the consular process. Then what's the next step? Well, the next step is for you or a representative from your human resources department to speak with an immigration lawyer to first check which employment visa is going to be the best one that will be able to achieve your goals and your employees' goals. You want to talk about that and see, because remember, as the employer, there are many requirements, many steps that you will have to take to ensure that you meet the eligibility, or that this person meets the eligibility, and that you as an employer too have taken every single step to prove to the United States government that number one, you're not going to exploit this person, and number two, that there's not an American that can fulfill that job. And there's specific steps. Your lawyer will be able to guide you on what those steps are, depending on which employment visa you are interested in obtaining for your employee. But it is possible. However, you as the employer is the one who must take those first steps. Again, just to recap, if the person that you're interested in, the candidate that you're interested in, has already accumulated unlawful stay, you will not be able to petition for them from within the United States. But if they leave the country and spend the time, whatever time they have a penalty outside, then you will be able to petition for them. Talk to an immigration lawyer, and we are here to serve you if we can help you. Our office is always open, and we do take remote consultations as well. This is Attorney Tanya Silva, leader of the Immigration Force, here to help you.